Okay, good afternoon, everyone, and welcome to this meeting of the Licensing Act 2003 Subcommittee, today the 29th of July at 2 p.m. I have a little list of stuff I have to read out here. These proceedings are being recorded. On the event of an appeal to the Magistrates' Court, a transcript will be provided to the court. Please bear in mind that whilst this is not a court of law, all parties will be given a fair hearing. All parties have had a copy of the procedure which will be adhered to. Please would all parties state their name and why they are present for the purpose of the recording.
Caroline Rawson, it's for myself, the licence for my property.
Thank you.
Richard Taylor, solicitor for the applicant.
Okay.
Louise Wilson, Health, Safety and Licensing Service Manager, here to represent the Licensing Authority.
Thank you.
Emma Appleton, Litigation and Regulatory Services Manager. I'm advisor to the committee.
Councillor Sean McMaster, member of the committee.
Councillor Jonathan Bibb, committee member.
Councillor John Dennis, I'm the chairman of this subcommittee.
And John Wiley, committee manager.
Yes, okay. My pieces of paper in the wrong order, but first point on the agenda is declarations of pecuniary, non-pecuniary and prejudicial interest. Members to declare any interests. No interest here either. So this is an application made under Section 17 of the Licensing Act 2003, Lazy Bean, Rothesay Court, Skirler. Okay, I can confirm that members have read all the documents provided by the parties. These proceedings are being recorded, and in the event of an appeal to the Magistrates' Court, a transcript will be provided to the court. Please bear in mind that whilst this is not a court of law, all parties will be given a fair hearing. All parties have had a copy of the procedure, which I've said already. Please would all parties state their name and why they are present for the purpose of the recording. We've done that already, yeah. Any too many of these. I can confirm that members have read all the documents provided by the parties. Further documents will not be accepted unless all parties agree. Are there any additional documents? No. Okay, thank you. Do the parties wish to call witnesses?
The way we'll do this, I will make the application, but of course Caroline's here as DPS and she's running this. If you've got any questions, then here. But I'm hired help. I'll do the talking.
Noted. Thank you very much. You calling witnesses? No. Okay. Thank you. The time limits for this hearing are opening statements 3 minutes, evidence from any witness 2 minutes each, questions of any other party or witness 3 minutes, summing up 2 minutes. We are flexible on this timing. They're a bit tight, really. Are all the parties content with the time limits?
Yes, thank you.
I now call on the licensing officer for any updates in relation to the application under consideration.
Thank you, Chair. Just the one to confirm for members that a set of photographs and plans has been circulated this afternoon, which is just to give members more information and understanding around the premises and the area it's located. Would you like me to go on and outline the application for you, Chair?
Yes, please. Yeah. Okay.
Thank you.
Okay. Thank you.
This is an application that's made under Section 17 of the Licensing Act 2003 by Caroline and Jack Rawson. This is for a new premises licence in respect of the Lazy Bean at 5 to 6 Rothesay Court, Main Road in Skirler, and the application was made on the 2nd of June 2025. The application can be seen in full at Members' Report at Appendix 1. The application is seeking the following licensable activities: the sale of alcohol, Monday to Saturday, from 9:30 a.m. until 0100 hours, and on Sundays from 10 a.m. until 2200 hours for on sales only. The applicant has also indicated the following opening hours: Monday to Saturday from 8 a.m. until 0130 hours, and Sundays from 10 a.m. until 22:30. The applicant has offered conditions as part of their application, and these are shown at pages 2 to 3 of your report. But members may wish to consider whether these are enforceable as written, whether they are statements or duplications of existing legislation. Further advice can be given to members on these conditions should you require it. The licensing authority is satisfied that the application has been advertised in accordance with the requirements of the Act by means of public notice on the premises, in the local newspaper and on the council's website. During the 28-day representation period, 2 relevant representations were received, and all representations received were from relevant persons residing in the locality of the premises. No representation has been received from any of the responsible authorities. When representation is received and not withdrawn, this matter must be determined by the Licensing Act 2003 subcommittee, who have the following options available to them this afternoon, as shown at section 5.1 of your report, which are to grant the premises licence as applied for, to grant the premises licence subject to the conditions mentioned in the operating schedule, modified to such an extent as the authority considers necessary for the promotion of the licensing objectives, to exclude from the scope of the licence any of the licensable activities to which the application relates, to refuse to specify the designated premises supervisor, or to reject the application made. Thank you, Chair.
Thank you, Louise. Are we all content with those? Yeah, thank you. Okay. On to the next point, applicant, opening statement and witnesses, please.
Thank you, Chair. So, as Louisa said, it's an application for a new licence, but it's effectively an application for variation, as Lazy Bean at number 5, Rothesay Court, already has a licence. And what we're seeking to do is effectively permission to sell alcohol in the bit that's already been knocked through. So we're seeking to extend the licensed area into the adjacent shop unit and just to extend the hours, and that's purely to give some flexibility so they can trade on occasions into the evening. As far as the premises is concerned, open March last year, immediately successful. I walked into your reception and there is a picture of Caroline on the front, having won the Chairman's Cafe of the Year award, East Riding award, and that's in its first year. And in the 16 months now that the premises have been open, there have been no complaints from any members of the public about licensable activities and no issues whatsoever with the responsible authorities. And so it was a success. The adjacent shop unit came up. Caroline talked to Faye in licensing, said you'll need a new license if you want to knock through. And we know you're doing the odd function in the evening. Why don't you go for slightly later hours so you don't need to keep coming back to us for temporary event notices? And so that's exactly what Caroline has done. And you've seen from the photos, I don't know if you've driven past, it's right on the main road in Skirler, opposite the Duke of York, by the mini roundabout. And I know that you've seen photographs of the inside. You'll see the quality of the premises, what it looks like inside. And let me tell you, the works that have been done do include some soundproofing. So what Caroline has created, premises with 10 tables, maximum seated capacity of 32 customers, although if there's a buffet or she's needing to cater for a wake, there could be more people in moving forward. And the idea is to really offer Skirler a neighbourhood bistro. Open evenings, pizza nights, whatever the nights might be, special nights, and then to be able to offer that private function should it be required. So Caroline's done everything properly, did all of the forms herself with Faye's help, for which she's very grateful. And 2 representations have been received. Now, I will say now, those representations were not a surprise to us. But let me put them into context for you. You will have seen the representations. You will have seen identical surnames. You will have maybe looked at a map and see that one lives next door, but one to the premises and one lives really some distance away. And it's no surprise to us because there is a minor dispute, precisely nothing to do with licensing, about car parking at the rear. And you will have seen on those photographs that you've seen 6 car parking spaces that says shop only or shops. There's 2 and then there's 4. Well, one of the local residents likes to park in them, and despite the fact that 4 of those are part of Caroline's lease, she doesn't, she wants to park in them. So it was no surprise to us that a constant complainer about car parking took the opportunity to make an objection to the licence. So that is the backdrop to the representations, but there are relevant points raised and therefore I must raise them. So what has been said? There will be noise. Well, we know that the premises have been opened later already. You've seen from Louise that the premises have been opening later on temporary event notice, and we know from Louise and Louise's report that no complaints have been received about that whatsoever. We see issues about car parking. Again, no surprise to us, but again, nothing that hasn't happened already. And then we see whether or not there's a need for the licensed premises and whether or not that that is necessary. Well, as an experienced committee, you will know that the concept of need in licensing disappeared in 1998. It's not something that we bother with anymore. The days of protecting other licensed premises are now long gone. So there we are, very basic application. Can the award-winning cafe move into it next door, part 1? And number 2, have longer hours to afford itself some flexibility when it's trading. That's all I can say. Thank you very much indeed. Caroline's here for any questions you might have.
Okay.
Sorry,
Thank
there
you.
was one more bit. Sorry, Louise outside raised an issue with one of the measures to promote the licensing objectives, which was suggested by Caroline, which is no children allowed into the premises after 9 p.m. each day. And her sheet very rightly says, what about functions can this be adhered to? And if you're minded to grant the application, would like just to discuss the wording of that, because what we would like is is children to be accommodated if this is a pre-booked private function, or we would like, if it's operating as a neighbourhood bistro, children to be accommodated after 9 p.m. if it's necessary to complete a meal purchased before 9 o'clock, just in case there's any delay with the kitchen or anything like that. Promise that's it this time.
Okay. Right. Thank you very much. Any questions, anyone? No questions? Okay. Thank you. We have no questions. So relevant persons, please stand up. No relevant persons in the room. Summing up, relevant persons first. No relevant persons. The applicant, you've probably done what summing up you're going to do, but
refers to paragraph 43 of the Annex Guidance, which is the part that says licensing committees should make decisions on the basis of it. So that, of course, comes out of the case law, Justice Black. Waitstone says we don't make our decisions on the basis of supposition guesswork that might happen or what somebody's predicting in the future. We make it on the basis of real evidence. So what I'm going to ask you to do is look at the real evidence in 2 parts, separated out. Is there any evidence for or against the division of the premises? Is there any evidence for or against the affording flexible house? And the answer is the evidence all goes one way. National operator, everything right. In all of the times the premises have been open, it's never been a complaint. Remember, all of the time the premises have been open, the evidence is they've been trading rates, they've been trading again. With no complaint whatsoever. Again, the role of responsible authorities. Very good evidence. They are the experts as far as issues license for activities. So paragraph 12 says each responsible authority is to be regarded as an expert in its own field of teaching the experts. Those are correct. Again, it's an experience which you know the experts of any problems whatsoever. They can very clear to tell us. So that is powerful evidence all one way. And on the other side of that, we have an object, we have 2 objects. So we expecting all object for providing precisely that by the way. So in all these services, I overstate. So
Thank you. As I said, we are flexible. We're used to this. It's absolutely fine. Policy advice from the licensing officer, please.
Thank you, Chair. Just the one point already mentioned, which is a revised and tweaked versions of the conditions offered by the applicant have been given to members should you be minded to grant the application today. I just ask that you consider those in particular where we've said that they are statements not enforceable or where they're duplicated by existing legislation. And obviously just a reminder in relation to box E, where it talks about children not being allowed on the premises after 9 p.m. and whether realistically that can be enforced. Given the nature of the business model proposed by the applicant to look at using the business for functions and private events. Other than that, that's everything. Thank you, Chair.
Thank you, Louise. Legal advice, please, from the legal advisor.
Chair, obviously the licensing policies and national guidance is helpfully well set out within the report. Obviously license conditions imposition dealt with at paragraph 4.3, so I don't intend to repeat that. But just a reminder that each application must be considered on its own merits and in accordance with the licensing authority's statement of licensing policy. Conditions attached to licenses and certificates must be tailored to the individual type, location and characteristics of the premises and events concerned. And this is essential to avoid the imposition of disproportionate and overly burdensome conditions on premises. All licensing determinations should be considered on a case-by-case basis, and they should take into account any representations or objections that have been received from responsible authorities or other persons, and representations made by the applicant or premises users as the case may be. As has been alluded to, authorities' determination should be evidence-based, justified as being appropriate for the promotion of the licensing objectives and proportionate to what it is intended to achieve, and similarly limited to consideration of the promotion of the objectives and nothing outside of those parameters. 10.9, just to point out that in some cases no additional conditions may be appropriate to promote the licensing objectives. That's confirmed within the guidance. Hours of trading is dealt with at paragraph 4.16. I don't intend to repeat everything that's detailed within the report. But just a reminder, as prevention of public nuisance, which is set out from paragraph 4.18, appropriate conditions should normally focus on the most sensitive periods. So, for example, the most sensitive period for people being disturbed by unreasonably loud music is at night and into the early hours of the morning, when residents in adjacent properties may be attempting to go to sleep or are sleeping. And just a reminder that beyond the immediate area surrounding the premises, these are matters for the personal responsibilities of individuals under the law, and an individual who engages in antisocial behaviour is accountable in their own right. Thank you, Chair.
Okay, thank you very much. We listed down here, I think it's the shortest agenda ever, but we're now up to private deliberations. So we would ask you to leave the room. We don't know how long we'll be, but give it half an hour and we'll see. Okay.
I'll come and collect if you're about.
Thank you. Yes, fine. Yeah, of course.